first case to come before the court is State versus Rosa, and there is no App.No argument today, so you will have the full 15 minutes.
Thank you, Your Honors. Good morning. May it please the court, Your Honors, before my time begins, I'd like to briefly introduce the family I represent. This is Ms. Rosa Saltos Bravo in white, together with her 3 U.S. citizen children. That's Holger to her left, and then Matthew, and then Andrew. Thank you, Your Honors. Good morning, Your Honors. May it please the court. I'm really not sure where the court wants me to proceed with this argument, but I decided to perhaps start off with discussing the issue of timeliness, because I think timeliness is a crucial factor in this case, since this motion to reopen and vacate Rosa's sentence was brought over 12 years since her original conviction back in 2004. Then I wanted to proceed on the issue of manifest injustice. If the court wishes to hear something else, or if the court has any questions, I'm sure the court will direct me accordingly. With regard to timeliness, the seminal case on this matter might be State versus Francis. In State versus Francis, the Supreme Court of Ohio held that timeliness is not a factor and not a controlling factor, certainly, in a respondent's motion to reopen a case. That's because in Francis, even though the motion to reopen had been brought several years after the initial conviction, the court held that timeliness was not a factor, especially in immigration cases where the issue of removal or deportation, as it was previously called, from the United States hinges on the federal government's decision on if and when to deport. In this particular case, Your Honors, we have a very similar circumstance. For the past 12 years, Rosa Saltos Bravo was not in imminent danger of being deported. In fact, it's very interesting to note that her initial appearance before the immigration court on removal charges was not because of her conviction in Summit County. Her initial appearance was because she had overstayed her validly issued and approved tourist visa to the United States. Rosa came to the USA legally, entering on February 6 of 1998 with her son Holger. Holger was already born. He was born in Ecuador. Rosa entered legally. Her problem was she overstayed. So the federal government charged her with a very simple immigration violation, which is overstay. On the basis of that violation, Rosa was certainly removable, but she was never removed because the federal government continued to grant her stay of removal after stay of removal. In fact, she is currently under what is called an order of supervision. With that order of supervision, which she's had for about the last 6 years, Rosa is entitled to legal work authorization, has obtained a legal work authorization card, has obtained a legal social security number, an Ohio driver's license, driver's insurance, and takes care of her 3 children, who are all U.S. citizens. Her 2 other children, Andrew and Matthew, were both born in the USA. In Rosa's case, matters came to a head approximately 2 years ago. In November 2014, President Obama announced something called an executive action. In that executive action, President Obama stipulated that individuals who had children born in the USA but who had entered either illegally or had fallen out of status in the USA could apply for some kind of a temporary protected status on the basis of their US citizen children. Last week, the Supreme Court essentially rejected that argument and denied President Obama's executive action on a split 4-4 decision, leaving the Fifth Circuit Court of Appeals stand. I regress, however, in relation to that November 2014 executive action, the Secretary of Homeland Security, J. Johnson, also issued another memorandum. In that memorandum, J. Johnson essentially said, if we are going to give benefits to aliens, we're also going to toughen up on our internal security measures. One of the priorities for removal became individuals who had been convicted of any felony. Not just aggravated felonies, which are mandatory removable from the United States, but even any felony. Since Rosa had 2 F5 felonies from her plea back in 2004, she immediately fell into this priority for removal. Indeed, USICE has been very generous so far and has permitted me time to reopen this case with the Summit County Trial Court and now appear before this panel in the hope that we can get this conviction vacated. Your Honor.
Was Rosa ineligible to apply for citizenship prior to the past couple of years?
She would have been, Your Honor, because she was ineligible.
Because of the 2004 conviction?
Because the only way a person can apply for, first you have to get permanent residency before you can become a citizen. The only way Rosa could get permanent residency would have been through either seeking asylum from her home country of Ecuador, or through an employment-based visa, or through a family petition. She did not qualify for asylum. She had no legitimate fear of returning back to Ecuador. She did not have a job that would qualify her for an employment-based visa. The only way she could qualify was through a family relationship. Her US citizen child, the eldest child, Holger, is now 21. Once he turned 21, he is eligible to apply for his mother to become a permanent resident. In order for a person to apply for their parent, he or she must turn 21. So until this April, when Holger turned 21, he could not apply for his mother. That application has now been filed. My office filed that application. So in answer to your question, Your Honor, that's why she was not able to file for permanent residency at any time leading up to the present.
Does Holger have a guardian?
Rosa is Holger's guardian. She was just appointed as guardian by the Summit County Probate Court.
So she would have to apply on his behalf for herself?
In a sense, yes. And we've already filed that application, Your Honor. We filed that application with the USCIS. May I continue?
Yes.
Thank you. Consequently, timeliness becomes an issue. And the reason I bring this up is because with the way that the courts have held, clearly an issue becomes when does an individual who has been previously convicted make a timely motion to reopen that conviction. And the answer is only when that individual's removal either is known ahead of time or becomes imminent ahead of time. The only time that the removal became imminent was in March of 2015, when Rosa appeared for her regular biannual reporting at USICE in Cleveland, when the USICE agent informed Rosa that she could be removed from the United States because of the J. Johnson Memorandum of November 2014. Consequently, right after that, in June of last year, the Summit County Trial Court entertained a petition to have the sentence reopened and vacated, and then subsequently this appeal was brought. This appeal was brought because the Summit County Court did not reach the merits of Rosa's petition. The Summit County Court did not even set a hearing on this matter. Case after case has indicated, including from this very panel and this very court, Your Honors, that there should, at the very least, be a hearing where a petitioner has shown that there is adequate factual evidence in the record to show that the case has merit, and number two, that the petitioner has been prejudiced by the underlying decision. The Francis case, in fact, said that the failure of a trial court to hold a hearing on a petition to reopen and vacate amounts to manifest injustice. So there's very strong case law in support of Rosa's case. The trial court's failure to hold a hearing amounts to an abuse of discretion. That's State versus Francis. In State versus Nero, the Supreme Court held substantial compliance with the statute means that in the totality of the circumstances, the defendant subjectively understands the implications of his plea and the rights he is waiving. As Rosa has indicated in her affidavit, which was filed with the Summit County Common Pleas Court and is part of the record, Rosa did not understand what she was doing.
Let me stop you there, because I have around 6 minutes left. In regard to that affidavit, when she said she didn't understand what she was doing, did she indicate that there were any problems with a language barrier?
Yes, there were, Your Honor.
Did she indicate that on her affidavit?
Yes, Your Honor.
Okay.
She indicated that.
What did she indicate?
She indicated, Your Honor, that she had never met with an interpreter, the same interpreter who came to court prior to the hearing in court. The only time she met the interpreter was at court, when she conducted her interviews and her meetings with her counsel, the counsel never provided an interpreter. Rosa would take someone who spoke very broken English who was a friend who tried to help Rosa
And
understand.
that's all in the affidavit?
Yes, Your Honor. Yes, Your Honor.
And I know she's from Ecuador. Is there anything in the affidavit as to any particular dialect, any particular language barriers in regard to the Spanish interpreter?
No, Your Honor, that is not a factor. Ecuador, unless she was an indigenous person, there would not be an issue. I have several Guatemalan clients who speak all kinds of very unknown dialects, but in Rosa's case, that is not
And
an
on
issue.
the record, it's clear that the interpreter was not sworn in?
That's, Your Honor, no, the interpreter was sworn in by the court.
Oh, I thought you said that that was one of the problems, that she was not sworn in.
Your Honor, I would have to look at the transcript. I don't have.
I think you indicated in your brief she was not sworn.
Okay.
She was not sworn in, and the court just gave it.
I do believe Judge Murphy asked the interpreter whether she was familiar with court, and the interpreter answered that indeed she was familiar with court, and she had interpreted in other courts as well. I can't truthfully recollect whether she had been sworn in or not right now, Your Honor. I'm sorry.
That's okay, that's okay. I'm just thinking 2004,
Yes, Your Honor.
trying to think if that would have been before the superintendent's.
Yes, Your Honor. There was well before the superintendent guideline, Rule 88, was promulgated, so.
But you still have state subpoena, which talks about the due process rights
Yes.
that are accorded to limited language learning individuals.
Yes, Your Honor. And my concern is that if the court will look at the transcript, there were several remarks made that were perhaps off-the-cuff remarks, which did not seem to, which seemed to prejudge the credibility of Rosa as well as her story. In fact, Rosa makes a passionate statement toward the end of the transcript when the judge asked her if she had anything to say. And she indicated, I did nothing wrong. I didn't do anything wrong. I didn't know it was a false document. I simply went and applied for my license and I received the license. Now, if someone makes a statement like that, and I've been an expert in several immigration-related matters in Summit County and other courts, if a witness makes a statement like that, if a defendant makes a statement like that, typically the court is going to stop the proceedings right there and say, you need to confer as to what's going on and come back and discuss this with me before I can accept this plea.
What about the appellee's argument that failed to attach the entire record? They're saying that reviews limited only plea hearing and sentencing transcripts, but none of the stuff that came before that is.
Your Honor, that would not have been relevant in any case because the two main issues that came up, and the only two times that Rosa had court with the interpreter present were these two times. So these are the two times. One was the actual plea deal. The first time would have been her plea of not guilty. The second would have been the actual plea agreement. And the third was the actual sentencing. And at the second and third is where the interpreter was present.
And you're indicating that did the court voir dire the interpreter whatsoever?
Very, very briefly in the transcript, the court simply asked the interpreter where the interpreter was from. The interpreter was not selected by the court nor paid by the court. The interpreter was brought by Rosa's attorney. And so the interpreter came in. She worked apparently for the International Institute. It's interesting because she said in her statement to Judge Murphy, she says, I represent the International Institute. Well, she didn't represent anybody at that point. She was just an interpreter. And then Judge Murphy asks her if she's had experience, and she says, yes, I've been in court on criminal matters. And that was about it.
But it is on the record that she was limited English proficient, that she could not.
Yes, Your Honor, that was the whole purpose of having the interpreter present. In fact, Judge Murphy does make a statement as to whether interpreter is needed or not when he asked Attorney Knowlton how many years Rose had been in the country, and at that time Rose had entered in 98, it was 2004. Attorney Knowlton said correctly 6 years, and Judge Murphy says, well, 6 years, I bet she speaks English just as well as you or I, but still proceeded forward with using the interpreter. So there's some question as to the ability of the interpreter to interpret. There's definitely an issue of whether with that very limited first time meeting an interpreter who actually could speak proper Spanish and proper English, whether Rosa had a chance to even discuss the implications of her plea. And it's absolutely clear, as Rosa stipulated in her affidavit, that Mr. Knowlton never advised her of the immigration consequences of her plea, nor did he seek immigration counsel's assistance to determine what ramifications there may be to such a plea.
Well, you indicated that the interpreter, according to our affidavit, was not present when there was.
That is correct, Your Honor.
And not that if you're in court, it doesn't matter if you're bilingual as an attorney, because you can't serve as an interpreter anyway. But in your interactions with your client, if you're bilingual, obviously that would help. But there's no indication that the attorney was bilingual.
Not at all, Your Honor. In fact, Rosa had to take a friend with her when she went to meet Attorney Norton.
And that's all in the affidavit?
Yes, Your Honor. So, it is. May I continue, Your Honor? Am I out of time?
You're actually out of time, but I'll see if the panel has any other questions. Thank you. If you wish to just sum up very briefly.
Your Honor, I will very briefly sum up. Rather than go through all of the case law, I will simply say, Your Honor, that in this particular case, what Rosa is asking for is a very simple rectification on the basis of due process. She's asking for either the case to be remanded for a hearing in accordance with this panel's ruling in several cases, including State versus Arunategui, where the case was remanded because the judge made a decision and overturned the verdict, or to make a decision yourselves and overturn the trial court's decision, denying her motion and vacating the trial court's decision and the conviction.
Of course, you realize that if we vacate, that just means she's still facing 2 felony charges.
Absolutely, Your Honor, she does. And then at that point in time, she would have to go back to Summit County Trial Court, and the prosecutor will have to proceed with their case, and she will proceed to vigorously defend it as best as she can.
Thank you, Counsel.
Thank you, Your Honors. I appreciate that. Have a good day.
The court will take the matter under advisement, and a written opinion will be sent to you and to the state, and it will be released on our website as well.
Thank you very much, Your Honors. Have a good day again.